Today's video is about a groundbreaking case that I was really interested to read, as we have been recently getting a tremendous number of queries and have been helping on divorce matters. This is a Supreme Court case that is still pending outcome in the Supreme Court, but was basically heard on the 30th of April of this year. So super latest news. Now, the facts of this case are Mr. Standish transferred £80 million to his wife, Mrs. Standish, who then filed for divorce. Now, the proposal and the issue around this case is whether that £80 million was matrimonial assets or non-matrimonial assets. In this case, the £80 million was earned by Mr. Standish prior to his marriage and was simply transferred to his wife for tax planning purposes. So this sort of brings to question the issue of the sharing principle that has been upheld in the courts. Now, at first, Mrs. Standish was awarded $45 million of this. The court later looked into this in a bit more detail and then whittled that $45 million down to $22 million. And now the case is pending because effectively none of that money was really supposed to be matrimonial assets, as the case may be. Now, there have been many cases like McFarlane versus McFarlane and another very interesting case in 2000, White versus White, where the sharing principle in a marriage and divorce proceedings has been established. For example, in White versus White, both of them were farmers. They were extremely successful, and then they proceeded to buy more farms, and then they had a pretty big asset pool of around 4.6 million pounds, and the court awarded Mrs. White about 1.6 million pounds simply because the court felt that it's not need-based. It's not necessarily Mrs. White requiring this money, but it was a fair allocation of the effort and of the fact that they had run this business jointly, etc. So there was a very established principle around the sharing concept and matrimonial assets. But then this case will be quite important when it comes to prenuptial agreements, separation agreements, and settlement agreements that we often end up doing because we live in the Middle East, where many parties who want to separate or want to be divorced end up having different nationalities, very different religious rights around the kind of marriage and how the marriage was solemnized. And there is a path under UAE law now where both Muslims and non-Muslims can effectively get divorced. I'll do this in my next video, but I also wanted to give a shout out to the litigation firm of Stewarts because they are the ones who reported the case of Standish versus Standish in depth, and we'll see what the Supreme Court ruling turns out to be in this case. Thank you so much for watching. Hope you're enjoying a different topic for the week, from golf to Greece to law to divorce.